Hi, this is Sherry, and I have the pleasure of having Scott Stafne of Stafne Trumbull in Washington State. He won the case recently of Bradburn versus Recontrust, where the Judge Bowden set the foreclosure aside. Hi, Mr. Stafne. Thank you so much for talking to me.
Hi, Sherry. How are you today?
I'm doing awesome. How are you?
I'm good.
Hey, thank you for talking to me. Can you tell me about this case? It was a Bank of America, correct? And Recon Trust.
Yes, yes, it was Bank of America, Recontrust, and Fannie Mae. And basically, this occurred about 4 or 5 years ago when they took his house. And there was a dispute about what happened, but we didn't argue about that. What we said is, hey, we don't want to talk about whether uh, Mr. Bradburn was in default. For purposes of our motion, we'll accept that he was in default. The real problem here is that the bank and the trustee violated the law. And we want the court to determine whether or not the law was followed. And the court determined the law was not followed. Now, this has implications in the state of Washington, primarily. It may have implications wider than that, but I wouldn't speculate on that. In Washington, we've had some rulings where our Supreme Court has decided that trustees which perform non-judicial foreclosures must act as neutral judicial substitutes, which kind of puts them in the same situation as if they were acting as a judge. What happened in that case was BANA had acquired the note, or actually the servicing rights, from Countrywide. And then they had appointed Recontrust their trustee. And of course, it all started out with a MERS deed of trust. Now, what happened was, of course, our Supreme Court in Bain versus Metro Mortgage Company said that MERS cannot be a beneficiary under our deed of trust for purposes of foreclosing non-judicially unless they actually own the note. And the whole MERS system was set up to make that not happen. The way they set the MERS system up was intentionally to sever the deed of trust or the security from the note. In fact, they even argued that in the Bain case. So after that came down, the banks had to find a different way to do things. And what they did in this case was they had their own subsidiary company, which of course is owned by Bank of America, owes all of its responsibilities to Bank of America, be a trustee. And so they gave the trustee a piece of paper, which in Washington we call a beneficiary declaration, and said, we want you to sell this house. And so they went ahead and they sold the house. But in Washington, we have a statute. It's RCW 61.24.030, 7, A, which says that before a trustee can begin any sale, that trustee has to have proof that the beneficiary is the owner of any promissory note secured by the deed of trust.
Right.
Well, they said outright that Fannie Mae was the owner. So if Fannie Mae was the owner and not the beneficiary, they started the foreclosure illegally.
Now,
you had wanted to say something, it sounded like.
Yeah, no, so 2009, this foreclosure happened, and wasn't he trying to do a modification at the same time? And I know you said that's part of that you didn't argue the part of default, but wasn't it that he was trying to do a modification, which millions of people are trying to do right now?
Well, yeah, that's the whole scam. And what goes on in Washington is, you know, and I know this goes on around the country too. Somebody will call up and say, hey, I need help, or they'll tell you, the bank will tell you, the servicer will tell you, do not pay your mortgage for 3 months. They tell you that will help you be able to get a modification, but it really doesn't. What it does is take people into a situation where the servicer can make money that would otherwise have to go to the people who have invested and are supposed to get money on the loan. So it puts them in a situation where they can keep the money rather than pass it on under most circumstances.
And this, I'm sorry, go ahead.
So that's what had happened to Jacob. And Jacob had, and this was after, of course, Countrywide went under and Bank of America took over. And I think it happened to a lot of people where, you know, they were trying to make their mortgage payments and Bank of America simply ignored the mortgage payments and either kept the money or didn't credit it, or just simply didn't take it and said they were in default.
Well, there's a lot of people that get foreclosed on in the modification stage, and there's been told to miss payments, and then they get foreclosed on when the bank was telling them miss payments so you can get modified. Now, this judge, actually, the foreclosure happened in 2009. He totally voided it. In the meantime, the house had sold, and so really that sale is also null and void, correct? That resale.
That's right. Although what actually happened is, and it went back to Freddie Mac, which they claimed was the owner. Of course, the problem was, as I said, our law requires the beneficiary and the owner to be the same, and they were claiming that BANA was the beneficiary and Freddie Mac was the owner, and they had a biased trustee, Recontrust, the wholly owned subsidiary, coming in trying to foreclose on Mr. Bradburn based on virtually a clear case where they hadn't complied with the statute.
And so it's also set up where he can file a civil court case in the way of getting money besides his house back, correct?
Well, we have a number of causes of action pending in that case. One of them was the Consumer Protection Act, and we sought a judgment of liability just on the Consumer Protection Act. Another cause of action that we have in that case is our state's Little RICO Act, which is like the federal RICO Act. And basically, if indeed what it may well be that the group here, Freddie Mac, BANA, and the not neutral trustee, Recontrust, committed numerous crimes in taking Mr. Bradburn's house away. Now, you've got to remember that if they did purposely violate the statute, and if they stole the house by using the DTA improperly, an argument can be made that they're engaged in racketeering activities, which are actionable in our state. So, in answer to your question, we went in on just one part of our complaint, which was the Consumer Protection Act. We still have in the background other causes of action. And I want to point out here, I mean, there's a lot of, the judge was very careful in his rulings. He took 5-6 weeks to decide this matter, and it's not as if the law is not clear. I mean, the law says that before a trustee, and you have to be neutral trustee, can foreclose. And he said this person wasn't even a neutral trustee, but even if he was, he would have to show that the beneficiary is also the owner of the promissory note. And in the facts before him, the undisputed facts before him, BANA claimed to be the beneficiary. They claimed Freddie Mac owned the note, and that in and of itself was a violation, which prevented them from proceeding with the foreclosure. So, I mean, the judge, I think, very carefully considered these issues, and he, I think if you have the opportunity to read his ruling, you'll see that he was concerned about what is actually going on with these companies. I mean, the implications nationally, of course, are Recontrust foreclosed on a lot of people.
Right.
If they weren't a neutral trustee and there's any sort of due process required, then that can be problematic. Now, there's a number of federal court decisions that are much earlier in time that say that you can, due process isn't required when you're simply dealing with no state action. But in a lot of states, and in our state, the statutes that originally may have granted non-judicial foreclosures may have been changed to where they have provided standards which are sufficient to indicate that there may be state action. In our case, it wasn't really necessary because our Supreme Court has said, look, the Deed of Trust Act has to be followed. And if you violate it, then you run the risk of having your sale voided. So if the statute has not been followed, which in Washington it wasn't in this case, and I think often is not, then you can argue, as we did, that the sale should be voided. Now, let me say that the federal courts, which are, in my experience, not as prone to read the actual language of the statute, come out with a different result. And consequently, I try to stay out of federal court, although now I'm going into federal court in a number of cases and asking them to certify these issues of state law to state courts. There's no reason that federal law, especially if a statute has been construed like ours, to be required to be consistent with our Washington Constitution, for the federal courts to be in there construing matters of state constitutional law. The federal courts do not derive, do not have any power on their own to construe the the constitutions of our states. And there's a guarantee clause in Article 4, Section 4, which would suggest that state republics should be allowed to declare their own rule of law for each state. These are arguments that are coming up now. But in Mr. Bradburn's case, it was a narrow decision that had an important result because it voided the sale.
Right. And I noticed that it was in the Superior Court in the way of state court compared to federal. And I'm so glad you mentioned that, because so many are filed in the federal courts. Now, you handle a lot of foreclosures, correct? I mean, you've helped a lot of people.
Well, I hope I have.
But you do handle, that's your specialty, is that correct?
Yes, that's my current specialty.
Okay, great. Because I'm going to make sure I will have all your information linked with this interview, and so people know how to contact you.
Well, it's not that easy to get through to me. Unfortunately, they can probably get through to the office, but we practice law in Washington State.
Right. That's what I need for those in Washington State.
Right. And what I would say to people is, and we do look at cases like Mr. Bradburn's, where we try to go in and void a sale, and we are looking at them in the context of personal injury claims, and where someone has clearly been damaged, we would consider taking those kinds of cases on a contingency. What I'd like to see happen is some cases like has happened, be won against the bank, which inspire many personal injuries lawyers to get involved in this field, to go against the banks, because we don't have enough lawyers interested in this field right now. It's a difficult one for lawyers, because lawyers, of course, have to pay their staffs and have to make money themselves in order to survive. And so the personal injury lawyers will take cases on contingency fees, thinking they will get paid in the future. So what we've got to do is win some of these cases, get damages, so that those lawyers will take these cases.
Well, I think
we also.
Sorry. No, MERS is a complicated situation, and that's what I have found in the way of speaking to a lot of lawyers, trying to get them involved in MERS, and it's a very complicated. A lot of people just don't understand it seems, and the complications.
Right, but people will understand things a lot better. I saw somewhere where some lady just got a $6 million judgment. When attorneys see those $6 million judgments, they will strive to learn the law a lot faster.
Right. Well, I want to thank you so much. I know you're so busy. I really appreciate you taking the time to discuss this case with me. And I do hope its ramifications and possibilities for everybody pretty much in the U.S., especially in non-judicial foreclosure states, of the Bank of America, the MERS, and the Recontrust, by having that.
Well, that won't help in non-judicial, it will help in non-judicial foreclosure states. It won't help in judicial foreclosure states.
Well, thank you, and you have an awesome evening.
Thank you very much. Appreciate it, Sherry.
All right, and I will have all your information up so people can contact you in Washington State.
All right, thank you.
All right.
Bye now.
Bye.